Well, today we're going to cover AI companies being held responsible for scraping books and other creatives' art from the internet. Strap in, this is going to be a rough one. Please subscribe, like, and comment below. Hit the notification bell to know when I release new content. Make sure you listen to my suggestions at the end of this video, as laws and lawsuits are just the beginning in protecting your work. Now, this isn't anything new. YouTube videos and articles have discussed this for months now, but the mix of whining and cheering for the settlement is disturbing. So let's begin. 3 authors started a suit in 2024. Their claim was simple and serious. They alleged that Anthropic had downloaded millions of copyrighted books from the internet, but also pirated shadow libraries, and used those books to train its AI systems. For authors, publishers, and anyone who creates original work, this case quickly became one of the most important legal battles in the AI world, because it was not just about one company. It was about a much bigger question. Can an AI company take copyrighted books, feed them into a machine, and call that fair use?
Yeah, but your scientists were so preoccupied with whether or not they could, they didn't stop to think if they should.
For the books Anthropic legally acquired and used for AI training, the judge sided with Anthropic on fair use.
Didn't steal anything yet. Don't you get it?
That part was not a win for creatives. Now, I will be honest, the way the judge explained the reasoning was confusing for a non-lawyer like me, but from what I understood, the court seemed to compare AI training on books to a human reading books, learning from them and then using that knowledge later in real life. That part just sounds strange to me.
They weren't thieves. They didn't steal nothing.
Because if I read a book and then rewrote another book using the same story, structure, characters, or expression, I could absolutely get sued for copyright infringement. But again, I'm not a lawyer. So maybe that makes perfect sense to the law nerds out there.
You sit on a throne of lies.
The big problem for me is this. Without seeing exactly how these AI models are trained or what they retain from copyrighted works in each generation, how do we know they are not using protected parts from those books? Now, the pirated books, that's a different issue. On that part, the judge allowed the lawsuit to move forward and even broadened it. According to court documents, Anthropic downloaded more than 7 million books from pirate sites. The company also bought and scanned millions more for possible use in AI training. At first, this was just 3 authors suing Anthropic. Then in August 2025, the case took a major turn.
You can't handle the truth.
The court certified it as a class action. That meant the lawsuit was no longer just about those 3 authors. It now represented a much larger group of copyright owners whose books appeared in the pirate library datasets and met the court's criteria. And here is where things got even more interesting. The class definition did not only include authors, it included all beneficial or legal copyright owners of the exclusive right to reproduce copies of any qualifying book. That could mean authors, publishers, or even estates. It could mean anyone who held the reproduction rights to those works.
Hell yes.
What started as a case brought by 3 individual authors became a mega lawsuit involving hundreds of thousands of works. Nearly 500,000 books were pulled into the case. And under copyright law, statutory damages can reach up to $150,000 per work. Now, that does not mean Anthropic was guaranteed to pay that amount.
Why are you the way that you are?
But theoretically, the company was suddenly facing potential liability of more than $70 billion. That is billion with a B.
Seriously?
Seriously.
So Anthropic settled for $1.5 billion, the largest copyright lawsuit in American history. The problem? Authors that were scraped and added to the lawsuit required a copyright registration to actually claim the settlements. You can only sue in federal court with a registered copyright. So for those who could join the settlement, many without registrations were screwed. Now back to the basic question. Are authors and creators protected by copyright? The simple answer is yes, but the better answer is yes, technically. And that word technically is doing a lot of work. Because in the United States, copyright protection starts automatically when you create an original work and fix it in a tangible form.
No shit.
That could be a book, a song, a photograph, a painting, a video, a screenplay, or any other creative work that qualifies under copyright law. So if you write a novel and save it on your computer, you have copyright protection. If you take a photo, you have copyright protection. If you create original artwork, you have copyright protection. But here's the part a lot of creators miss. Copyright protection and copyright remedies are not the same thing, and remedies are where the real power is. A lot of people hear, "You're protected by copyright," and think that means that they are fully protected. But copyright is not a magical shield that automatically stops people from stealing your work. It's more like a legal right that gives you the ability to do something after your work is copied, stolen, distributed, or used without permission. And that is where registration matters. Because yes, your work is protected the moment it is created and fixed in a tangible form. But if you want to sue for copyright infringement in federal court, you generally need a copyright registration first. More specifically, for most US works, you need the Copyright Office to have registered the work or refuse the registration before you can file the lawsuit. That is a huge difference. Because imagine someone steals your book cover, your art, your photo, your video, or your novel. You may own the copyright, you may be right. They may be wrong. But if you have not registered the copyright, your legal options are much weaker. You have to register first before you can even get into federal court. By the time you do that, the damage may already be done. That is why I think creators need to understand this clearly. Copyright exists automatically, but enforcement is a separate issue, and enforcement costs money. Federal court is expensive. It is complicated and very slow. And for most independent authors, artists, photographers, and creators, it can be completely out of reach. That is why attorney's fees matter so much. If you timely register your copyright, the law allows you to recover attorney's fees if you are in federal court. That changes the entire economics of a case. Because if attorney's fees are available, a lawyer knows there may be a way to get paid at the end of the case. That can make it easier for a creator to find representation. It may mean an attorney is more willing to take the case with a contingency instead of a huge retainer up front.
Compassion. That's the one thing no machine ever had.
But without that possibility, the creator may be stuck. You might be told, yes, your work was stolen, and yes, you have a claim. Now give us $20,000 to start fighting for you. And for a lot of creators, that means the case is over before it begins. So when people say, don't worry, copyright protects you, my response is, okay, but can I afford to enforce it? Because a right you cannot afford to enforce is not much of a right in the real world. Now let's talk statutory damages. Normally, if someone infringes your work, you may have to prove actual damages. That means you have to show what you lost or what the infringer gained. That can be very hard.
That's what she said.
How do you prove exactly how much money you lost because someone used your image without permission? How do you prove how many book sales you lost because someone uploaded your novel to a pirate site? How do you prove what a company gained from using your work as part of a larger product platform or AI training dataset? That is where statutory damages can matter. Statutory damages allow the court to award money within a legal range without requiring you to prove every dollar of actual loss. In federal court, statutory damages can range from $750 to $30,000 per infringed work. If the infringement is willful, the number can go up to $150,000 per work. If the infringer proves they were innocent, the number can go down. But again, there is a catch. For many creators, statutory damages are only available if their work was registered on time. That usually means before the infringement happened, or within 3 months after first publication. That is why registration is not just paperwork. It affects the remedies, your leverage, and whether the infringer takes you seriously. Because if all you can say is, you stole my work and I can maybe prove I lost $200, that is one kind of conversation. But if you can say, this was registered, attorney's fees may be available, and statutory damages may apply, that is a very different conversation. Now, because federal court is so expensive, Congress created something called the Case Act of 2020. The Copyright Office began the work of setting it up in 2021, but the Copyright Claims Board itself launched on June 16, 2022. The Copyright Claims Board, aka Copyright Small Claims, was a simple idea. The idea was to create a smaller, cheaper, more accessible copyright claims process for creators who could not realistically afford federal court.
I don't think it means what you think it means.
And on paper, that sounds great. Instead of spending a fortune to sue someone in federal court, you can bring a smaller copyright claim through the board. So from launch through December 31st, 2025, the board received more than 1,700 claims. In its first year, 487 claims were filed. In its second year, 393 claims were filed. And its third year, 462 claims. And from June 16, 2025 through December 31st, 2025 alone, 340 claims were filed. The Copyright Office said that put the board on track for its busiest year yet, potentially more than 600 claims in its fourth year. That tells me creators are using it. But here's the important part. The board is not producing thousands of final rulings. As of December 31st, the board has issued 43 final determinations. That number sounds low until you look at settlements. According to the 2026 Case Act report, the board had held 27 settlement conferences, and 17 of those later resolved by settlement. The report also says 136 proceedings were dismissed because of a known party settlement. On top of that, more than 100 additional proceedings were voluntarily dismissed, and the report suggests some of those were probably settlements too. So the real value of the board may not be that it gives everyone a final judgment. The real value may be that it pushes people to take copyright claims seriously enough to settle. But now we get to the big weakness. So the Case Act can be useful, but it is not a magic solution. As you go through the door to sue them, the other side can refuse to walk through it. And if they refuse, you may have to go right back to the expensive door. As of December 31st, 2025, the report says 181 respondents had filed opt-out notices, and 152 proceedings were dismissed because all respondents opted out. See, under the Case Act, the respondent gets notice of the claim and has 60 days to opt out. If they do nothing, the case can move forward and possibly default judgment given. If they opt out, the case is dismissed without prejudice, which means the creator can still sue in federal court.
But think about what you just said.
The report estimates the opt-out rate at roughly 1/3, depending on how you calculate it. That sounds fair from a due process standpoint, but from a creator standpoint, it can feel frustrating because you may file in the CCB thinking, finally there's an affordable way to handle copyright infringement. Then the other side simply opts out. Well, now what? Now you are right back to where you started. That is why I call the Case Act a cheaper option, but not a complete fix. It gives creators another tool, but it does not replace the power of registration, and it does not eliminate the burden of federal court if the other side refuses to participate. So after all that, here's my practical advice to authors and creators. Register the damn thing. I am saying that as a creator, not as a lawyer. Yes, copyright technically exists the moment you create the work and fix it in a tangible form. But if you actually care about protecting your work, do not stop there. Go to the Copyright Office website. I'll post the link in the description of the video. Create an account by clicking the link to register, then fill out the application.
But it's so hard. God.
You will need basic information like the title, the author, the claimant, whether the work is published or unpublished, and the year it was created, plus the manuscript. Then you pay the filing fee. And compared to the cost of trying to fix this later, the fee isn't that bad. Their own circular lists online registrations at $45 for a single application and $65 for standard online applications. There's also group registrations up to 10 unpublished books. For an example, I had 2 registrations, books 1 through 3, then books 4 through 7, $85 each. It's worth it.
How long does it take?
After you file, it may take a while. In my own experience, it took about 1 to 3 months to get the registration certificate back. But once it is done, you have something much stronger than "trust me, I wrote it." And it makes your claim look a lot more serious when someone steals your work. If you can register for a Library of Congress control number and buy ISBNs, you can do this too. Now here's another thing a lot of authors and creators miss. Registration and mandatory deposit are not exactly the same thing. The Copyright Act has a requirement called mandatory deposit. If you publish a physical work in the United States, the Copyright Office generally requires that copies be sent to the Library of Congress. For books, that usually means 2 complete copies of the final published book, the best edition sent within 3 months of publication. So if you publish a paperback or hardback, do not just register the digital file and forget about it. If you are physically selling the book, send in the physical copies. If you are selling CDs of music or audiobooks, those physical items may also trigger deposit requirements. The same general idea applies. If it is physically sold and published, just deposit the damn thing. Now, for online works, the rules can be different. Many online-only works are generally exempt from mandatory deposit requirements, unless the Copyright Office specifically demands them.
That's too much information.
And here's a simple version for authors. If you publish a final physical book, send 2 copies to the Copyright Office within 3 months of publication. That's it. The address is in Circular 7D from the Copyright Office website search bar. Keep the tracking number, keep the receipt, keep proof of the date you sent them. Just send the required copies and keep your tracking information as proof that you complied. I'm just going to plead with you for 1 minute. Please copyright your work, send the mandatory deposit, and be protected. You do not want to be left out of a class action lawsuit settlement. You do not want to be left out of a federal lawsuit requirement. Please just do it and register your works. And that includes everyone from authors to artists to musicians. Just please do it. It will save you so much hassle in the long run.
With great power comes great responsibility.
I know this video is very administrative and procedural, so I'll leave you with this. Mike Ditka famously said, "What's the difference between a 3-week-old puppy and a sports writer? In 6 weeks, the puppy stops whining." Thanks for watching.